After the brilliant presentations we had earlier about mortgages and investment regulation and so forth, I think we all deserve a holiday. Unfortunately, I cannot give you this, but at least we can talk about holidays for a period of time now. And some of you will work advising on holidays, advising consumers or advising traders about holidays. But even if you don't, hey, we all love holidays, don't we? We all go on holidays, so we all like to know what our own situation and our own rights are. In fact, funnily enough, this morning I had an email from my son who has a query about some travel of his which went wrong, and he wants to know what his rights are. So we're all in that situation. So I'm from Traveller in England, and there are some of my colleagues modelling our exclusive range of leisure wear. Moving straight on, the Package Travel Directive, the new one, we've had for, the text of it for almost 2 years now, but things move slowly, and it's only now that we're approaching implementation. It's due to be implemented on the 1st of January 2018 and comes into force on the 1st of July 2018. Of course, there are long lead-in times in the holiday industry because people, for example, people are already selling holidays for the winter 2018-19 season, so plans need to be put in place a long way ahead of time. In the UK, we've been very slow to get round to implementing this directive. I think we may have one or two other European issues that we're worrying about in priority to this one. You can ask me about that. When it comes to the question time, you can ask me about that instead of package travel if you want. But anyway, we've had two consultations, one about what is called the ATOL scheme, which is the financial protection scheme run by the Civil Aviation Authority. I saw there were two people from the CAA on the delegate list. Oh, there you are. Hello. I'd like to know where. And also from the Department for Business have just completed taking responses to a consultation on other aspects of this new directive. So I suspect in the UK we'll get the regulations published at about 5 to midnight on the 31st of December. But anyway, we'll see. Other member states are further ahead. I think the Germans are, I think the Austrians are, and I dare say probably everybody else is as well. But you'll be able to tell me about that. Okay, moving on. So there are some major changes, 2 or 3 absolutely crucial major changes, but also quite a lot of smaller but still important changes in the new directive. One of the major changes is the definition of package. The old definition, dating back to 1990, predates well, basically predates the internet and low-cost airlines and the whole model on which the travel industry now operates. So the old definition is way out of date. Now, the old definition, just to remind you, was a pre-arranged combination of at least 2 out of 3 of transport, accommodation, or other tourist services sold or offered for sale at an inclusive price. And it's turned out over the last 30 years or nearly 30 years since we've had that definition that the key words which have caused all the trouble are the words inclusive price. And in our jurisdiction it's ended up with a lot of authoritative court decisions on what is meant by an inclusive price, And perhaps the best explanation was given in one of the cases, an analogy with going into a supermarket. If you go into a supermarket and you take your shopping basket, which is an interesting expression if you shop online and you know about buying things and putting them into your basket before you go to the checkout. Buying, if you go in a supermarket, you put your bread and your butter and your sugar and whatever into your shopping basket, you go to the checkout, and when you get to the checkout, what is it that the checkout operator asks you for? Is it an inclusive price? Answer, no, it's not an inclusive price, because all the checkout operator does is add up the cost, the advertised cost of the bread and the butter and the sugar, come to a total and asks you for that money. And that is a total price, not an inclusive price. That's what the cases say anyway. Therefore, if you have an arrangement like the online travel agents have, whereby you go, you buy a flight, and you choose, shall we say, you select a flight, and you put that in your shopping basket, and you select a hotel, and you put that in your shopping basket, and then you go to the checkout, and then at that point, having given you the prices for the flight and the hotel, it then adds them up and asks you for a total, which you then give your credit card details or whatever to buy them. And those are not packages, they're not covered by the existing directive, mostly because that is not an inclusive price. So what the Commission have done is to create a new definition of package. And instead of having one definition, we now have 6 definitions of packages. And what the EU hopes it has achieved is to capture almost everything within the definition of package, almost all possible combinations of travel services. Can I just say, before I forget to say it, business travel, which is currently included, is going to be excluded from the new directive. So business travel will no longer be protected. It's a bit more complicated than that, but as a rule of thumb, that will do for now. So, what is the new definition of a package? Well, the first definition, which is the letter A up there, is really very similar to what we have now. It's the traditional package. The services, which are now transport, accommodation, other tourist services, or car hire or other vehicle hire. So we've got 4, so any combination of at least 2 out of those 4 things. So if the services are combined by one trader, including at the request or according to the selection of the traveller, before a single contract on all services is concluded. So that's pretty much the package as we know it now. So we'll ignore that and move on to the parts which are new. And these are the new bits. Definition 2 starts with little b. Irrespective of whether separate contracts are concluded with individual travel service providers. Let's just pause there for a second. So it doesn't matter if technically, if you go on an online travel agent website, and technically you're buying through that website, you're making a contract with the airline to buy a flight seat, and you're making a contract with a hotel for your stay there, and a contract with Avis or Hertz or somebody for your rent-a-car. It doesn't matter if they're all separate contracts. If you're buying through the same website or the same point of sale, it can be a travel agency shop, it can be a telephone sales facility, it can be online, whatever. If through one trader you're buying these services, they're being combined, then it doesn't matter whether it's under separate contracts. So, And that governs all these definitions. Whether or not it's separate contracts, if it's purchased from a single point of sale and the services have been selected before the traveller agrees to pay. Okay, so it may be separate, it may or may not be separate contracts with the airline, the hotel, etc., but you bought them through one website, one call centre, whatever, and you've selected them all before you agree to pay. That's a package in future. Secondly, and this to me is the most important one of all, if, again, regardless of whether it's separate contracts you're making, if they're offered, sold, or charged at an inclusive or total price. So now all that case law, which is developed over the last 30 years about what does an inclusive price mean, we can forget all that because it doesn't make any difference now. Whether it's an inclusive price or a total price, it's going to be a package. So your supermarket analogy, you buy the different elements, you go to the checkout, it's still, even if they're individually priced and all they do is add them together, it's still going to be a package. Thirdly, advertised or sold under the term package or a similar term. Well, I don't think any holiday companies have got any reason to complain if they describe it as a package and the court decides that therefore it's a package. That's not very revolutionary. But I wonder what a similar term to package is. Is holiday a similar term to package, for example? I suspect it might be. You know, when you think about all these definitions, you can think grand, academic, clever thoughts about, is it this side of the line or is that side of the line? Let me suggest to you, don't do that. Let me suggest to you instead, you think about this. When and how is it ever going to be decided whether it's a package or not? Answer by a judge. Why is the judge going to have to make that decision? Because somebody has gone on a holiday and they've been perhaps seriously injured during the holiday while they were in the hotel or whatever, and they're bringing a claim. And the only decision the judge has to make is, was this a package or not? Because if there was a package, there was liability for things that go wrong in it. I'll come to that in a while. But if there is no package, then there is no liability, and so the poor injured consumer will get nothing. Okay? You're the judge. What are you going to decide? And we don't even have any set of facts. Forget about facts. You know, we're in a post-fact society now. On what you know already, you've got this injured consumer, and all you have to decide is whether it's a package or not, to give them compensation. What are you going to decide? Hands up for yes, it's a package. And hands up for no, it definitely isn't one. One, right. Thank you, Peter. So I think you see that all the academic exercises in the world about which side of the line this definition comes, I think it's really, you've got to keep your feet on the ground. You've got to think in the real world. Who's going to make these decisions and why? And what prejudices will be in their mind. In their mind, the prejudice will be to award compensation to this poor, injured person if they can, and only if it's absolutely, clearly, blatantly not a package will they not make that decision. Okay, moving on. So we've had 1, 2, 3, 4 of the 6 definitions so far. 5 I'm going to ignore. It deals with gift boxes and things which are quite unusual and rare. And 6, which is Roman 5 here, just to be confusing. And final definition of package is what we call a click-through. So purchase from separate traders through linked online booking processes, where the traveller's name, payment details and email address are transmitted from the trader, the first trader, to the second trader. And a contract with the second trader is made no more than 24 hours after the first booking. So you go on website A, for example, you buy a flight, it says, would you like to but have a hotel as well. You say yes, you click through, you go to another website, which has already got your name, your email address, and your credit card details, and you buy a hotel within 24 hours. That's then a package. The first trader, Trader A, has sold you a package in that scenario. However, I'd be interested in what you say about what happens in your countries, but certainly in our country, it's actually rather rare, particularly for credit card details, to be transferred in that way. I think we're going to hear later about data protection type issues, but certainly it's unusual to in the UK for that to happen. So therefore, I don't think that, although I can see that was a good idea to have that as a defined as package, I don't think that's going to make a huge impact on the law. So what they did in Brussels was they tried to make these definitions so wide that they would capture as much as they possibly could as a package. And if you sell a package, and I'll come to the detail, but just to give you a heads up on this now, if you sell a package, it must be financially protected, so if the company goes bust, the consumer gets their money back. And also, there is protection, as I've already hinted, for things that go wrong. If the cleaner leaves the hotel floor, marble floor, wet without putting up any warning signs and you fall over, as a consumer you can bring a claim, or the swimming pool hasn't got depth markings, or whatever it might be. They've tried to capture as much as possible, and you have that protection. But just in case there are things which slip through the net and are not packages, the EU have created something new to catch those, and that new thing is called a linked travel arrangement. My God, that's a sexy name, isn't it? A linked travel arrangement. Now, what is a linked travel arrangement? Well, there is a Type A linked travel arrangement and a Type B one. So the Type A one means at least two different types of travel service. So we're back at, transport, accommodation, tourist services, or car hire. At least two of those. Purchased for the purpose of the same trip or holiday, not constituting a package, so it's not a package. And there are separate contracts with individual service providers if a trader facilitates A, on the occasion of a single visit or contact with the point of sale, the separate selection and separate payment of each travel service by travellers. Okay, so that's a Type A linked travel arrangement. I don't think there will be hardly any of those. And why is that? Well, again, imagine that you're in a travel agency shop, because it's easiest to imagine that. But the same applies if you're on the telephone, or the same applies if you're online. But let's imagine you're in a travel agency shop. And you go and you say, okay, I would like to go for a week in Marbella, please, in the south of Spain. And the travel agent goes on the computer and says to you, okay, good, I've got this flight. I found a flight going to Malaga Airport. It's £100, €100, and shall I book it for you? What is the customer going to say? They're going to say, whoa, hold on a minute. I want to know if there's a hotel, don't I? Before I commit to paying for the flight, I want to know there's a suitable hotel available for me. Or if the other way around, the travel agent says, I found this nice hotel, it's available, give me your credit card and I'll get it booked. Again, the consumer will say, hang on, whoa, stop. I don't even know if, I need to know I can get there at a price I like before. So I think separate selection is very difficult, and separate payment, because the consumer will always say, rightly I think, They weren't separate, they were interlinked. Remember, go back to my test. When is this ever going to be decided, whether it was a package or a linked travel arrangement? Answer, because the consumer was injured during their time away and they're bringing a claim, and the judge has to decide. The consumer says, well, no, it wasn't separate selection because I wouldn't possibly agree to just buy one on its own without knowing that I had all the other elements in place as well. They were interlinked, they were interdependent. So that seems to me that type A linked travel arrangements are very rarely going to happen. There's quite an interesting gloss, and I'd welcome any comments you may have on this. But I understand that in the German implementation of this directive, that they've created a different definition, apparently with no authority from the directive itself at all, in which they say separately chosen and separately paid, or the customer declared his general consent to pay separately, but practically will do so in one invoice. I'm not quite sure what that means. I'm not quite sure what the impact of that will be. It certainly doesn't seem to be in line with the wording of the directive. So we shall see what happens when consumers bring claims under their rights under this directive and the member state regulations made under it. Okay, so that's a type A linked travel arrangement, rubbish. Type B probably has more legs. This is, again, we're in the world of click-throughs. Remember, I said package type click-throughs are going to be rarely happen because I believe it's rare for the email address and credit card details to be transferred to a second website automatically. But here in linked travel arrangements, in a targeted manner, so you've got two or more travel services sold on the occasion of one visit to a website or a shop or a telephone sales. In a targeted manner, the procurement of at least one additional travel service from another trader, and where a contract with such other trader is concluded not more than 24 hours after the confirmation of the first travel service. So here, I think, so in effect, that is a click-through where there is no transfer of the personal data, like email addresses and credit card details. So I think that is much more likely to happen. So I do think that type B linked travel arrangements will exist under the new directive. As we shall see in a minute, the protection consumers get from a type B linked travel arrangement is very small indeed. So what is the protection? It's in Article 19. It says, member states shall ensure that traders facilitating linked travel arrangements shall provide security for the refund of all payments they receive from travellers insofar as a travel service is not performed as a consequence of their insolvency. If you just think about this for a minute, you'll see that the protection is really weak. So trader, you go on website A, you pay for something, maybe it's a hotel, and then you click through and you buy your flight from trader B. Okay. All that's protected is the money given to trader A. It's protected only against their insolvency and not the supplier's insolvency. You know, if it's a package you bought, you're protected against your trader's insolvency or their supplier's insolvency. But here it's only if the trader goes insolvent. It's only the money you gave trader A. The money that you gave to trader B is not protected at all. And Also, it's only protected for the length of time that Trader A holds that money. So the minute they pass it on to the supplier, the protection is lost. So the protection for a linked travel arrangement is really weak. And of course, there is no protection for the quality of the service, for the safety of the service, and all the other things, the description of the service, all the other things which if you buy a package as a consumer, you have all those protections. So linked travel arrangements are pretty weak. But I say again, they were only intended as a backstop by the Commission in case somebody managed to not sell a package. Okay, moving on. One thing that I think will come up a lot is that if a trader says, I sold you a linked travel arrangement, not a package, the next rule on the screen shows that before it is a linked travel arrangement, the Trader A has to serve on the consumer a notice that the traveller will not benefit from any of the rights granted by the directive exclusively to package travellers. And they have to use the form set out in Annex 2 of the directive. So, given that Trader A won't know there's a linked travel arrangement until Trader B tells Trader A, did you know I've sold something as well? Then Trader A has to serve a notice on the consumer that it was a linked travel arrangement. I think that's going to go wrong lots of times. And if the notice is not served as required, then the result is that it's treated as a package. So the consumer suddenly has the rights, the financial protection rights, and the rights to sue when things go wrong, as if it was a package, just because that notice wasn't served on them. So I think that's traders are going to go wrong on that all the time, in my opinion. So consumers will be protected. Okay, moving on. Once you've made a booking, traders can only increase the price pre-departure by a maximum of 8% without allowing the consumer to cancel free of charge. And it can only be for very limited reasons: fuel costs, increased government taxes, or exchange rates. There's no other reason allowed. The current directive says nothing about cancellation charges. That is where the consumer decides they don't want to go. They booked a holiday, but they decide they want to cancel it. The new directive does say that traders are allowed to charge an appropriate and justifiable fee. Reasonable standardised cancellation fees are allowed, but there is a requirement that these fees be justified when called upon to do so. There's a brand new right for consumers to cancel their holiday without paying cancellation charges if there are unavoidable and extraordinary circumstances at the place of destination or its immediate vicinity which seriously impact upon the package. I was thinking, you know, all the hurricanes that have been in the Caribbean in the last few weeks. I was thinking about this new provision, obviously not in force until 2018, but even so, imagine it was in force. And what would be the situation if consumers say, do you know what, I don't fancy going to the Caribbean anymore. I know I'm booked to go to Island A, and the weather forecast says that the hurricane's going to hit Island B, but you never know because hurricanes change course and so on. It's in the immediate vicinity. Will they be allowed to cancel free of charge in those circumstances? A lot of question marks about that sort of thing. No doubt there will be lots of cases testing what all this means and what immediate vicinity means as well. There isn't really much change on liability. Basically, traders are strictly liable for misdescribing a holiday. They're strictly liable for the quality, if the quality is substandard, if they've sold a package. As far as injury is concerned, certainly in the UK, there is a need for consumers to prove negligence on the part of the supplier, that the hotels, it's usually the hotel, can be a coach transfer or something, but where the injury happens, or a ski lesson or something like that, that's part of a package. In the UK, there's usually a need for the consumer to prove that the supplier has been negligent, and negligent means that they've broken the local standards applicable. So if you go through a glass balcony window and you say the glass was not of the type which complied with the local standard for the country where the hotel was, then you've got a claim. But if the glass fully complied with the local standard, then you probably haven't got a claim, because it's not negligent to run a hotel which complies with the local standards applicable in that country. So the new phrase is lack of conformity. The consumer has to show a lack of conformity, but I don't think that actually makes any difference to the existing law. There's a new right where a consumer can't get home in a force majeure type situation at the end of the package. For example, of course, the famous ash cloud from a few years ago, but there are more common examples like snow has closed an airport, or a hurricane or something like that. Then there is a new requirement on the organizer of the package to pay for a maximum of 3 nights extra for the consumer, hotel and other living expenses, meals and so on. So it's a maximum of 3 nights. Not many things go on longer than that, but if it did go on longer than that, then the consumer has to pay from that point on. Consumer should take insurance, of course, to cover these things. There's a new obligation, a new duty of care on tour organisers. It's quite interesting. In the old law, the duty of care only applied where there was a breach of the obligations, or there was a breach, but for some reason the organiser wasn't liable, perhaps because it was force majeure or something like that. But now there is a big, wide duty of care. Any problem which arises to a consumer during their holiday, even if it's nothing to do with the package, if they get knocked down while they're crossing the road in the resort, if they get food poisoning in a restaurant which they've chosen to go to themselves, if they get mugged and robbed in the street, it doesn't make any difference. Or, of course, if it is connected to the package, the organiser must look after the consumer, give appropriate assistance without undue delay to the traveller in difficulty, as the wording is set out. They don't have to pay any money for this. They just have to give assistance, help them, advise them, help them make alternative transport arrangements if needed, help them get in touch with, their credit cards have all been stolen, help them get in touch with reporting it, whatever, help, assistance. It doesn't mean paying for anything. So what does all this mean? Well, I think it definitely means an increase in the number of claims, including quality complaints, complaints about descriptions were inaccurate, injury, and of course illness claims. Some of you may be aware that in the UK we have a massive problem at the moment with fraudulent illness claims. It's either that, or we Brits have got particularly weak stomachs, which doesn't affect the rest of you, apparently, because the statistics show a staggering 500% increase in illness claims over a period of 2 or 3 years among Brits, with no equivalent increase in illness claims from Germans and Dutch and so on and so on. staying in the same hotels, of course. And part of the reason this famous photograph of a converted ambulance parked outside a hotel in Tenerife, I think it was, in which consumers are invited to go into this claims clinic, and then they're signed up to bring a claim and told they'll get lots of money, and they should say they haven't eaten anywhere except in the hotel. They should say all their family were ill. They should say they fell ill 3 days after they arrived in the hotel, etc., etc. So our government is trying to deal with that slowly, but there will inevitably be an increase because there would be an increase in packages. Loads more packages, so loads more claims. What about the impact for the new, high street travel agents selling packages for the first time? What are they going to do about health and safety auditing of hotels? They'll have to have public liability insurance in respect of potential claims. They'll have to comply with the information giving provisions. It seems, though, that they will still be able to avoid Tom's VAT because they can still say they are agents as well as organisers of packages at one and the same time. So move on. So the final point I want to make is a very important change in the new directive, and it's about the place of regulation. Now, don't all go to sleep. We'll try and keep this lively. The place of regulation. At the moment, every company that sells packages has to be regulated wherever the consumers are that they are selling to. So if you're selling to Brits, you need to be regulated in the UK. If you're selling to Germans, you need to be regulated in Germany, and so on, and so on, and so on. And that means that for cross-border companies like Expedia or people like that, they need to be regulated in every country which they sell in, which is, of course, complicated and time-consuming and expensive, and contrary to the wishes of the European Union to facilitate cross-border trading. So under the new directive, there is mutual recognition. No, I've jumped the gun there. First of all, you are only regulated once. You are regulated in your place of establishment as a company. Now, don't ask me what a place of establishment is, because it's all set out in some tax legislation, which is far too complicated for a simple person like me. But I know what it does mean, a real head office. It doesn't mean a PO box office number or one person sat in an office upstairs somewhere. It means a real head office, a real headquarters. Now, once you have that in one EU country and you are regulated there, then you can sell on that basis throughout the whole of the EU. So if you're regulated in the UK, that will enable you, subject to Brexit, of course, but that will enable you to sell to consumers in Germany, in Italy, and wherever. And similarly, if you're a tour organizer in Germany and you're regulated in Germany, you can sell again to any country in the EU. So that is a great boon for traders. It will reduce their overheads, hopefully reduce therefore the cost of holidays as well, and enable and empower cross-border trading. There are, of course, some potential issues for consumers arising out of this new. For example, in the UK, a company called Low Cost Holidays went bust a year or so ago, and they had moved their headquarters from the UK to the Balearic Islands, to Mallorca. And it turned out that they had a bond which had a value of just over €1 million or something, but they had over 100,000 consumers still to travel or stranded in resort at the time when they went bust. So that was nothing like enough money. So you worry a bit that if for example, the companies decide, oh, let's all move our head office to, I don't know, I don't want to upset anyone, but if you decide to move your headquarters to, shall we say, Latvia or Bulgaria or somewhere that you might think was a lot cheaper to operate than the UK or Germany, then you would worry as a consumer, will the protection in place be enough to protect my money? Now, I'm hoping that the Commission is doing some work to get a level playing field of protection throughout the European Union. The rules for that don't appear in this directive. What does appear is the requirement that each country recognises as valid the protection of each other, all the other member states. Right, okay, so that's, and we had a company called Monarch, about the 4th or 5th biggest company in the UK in the holiday field, airline and tour operator, went bust about a week ago. And a very strange thing happened. Low-cost holidays, a very strange thing happened. Most people had booked by debit card. Why? Because, of course, until the new PSD2 comes in next year, people are charged extra for using a credit card. So they use a debit card, and theoretically, that doesn't give you the same protection. But in fact, the debit card companies behave the same as the credit card companies and refunded everybody's money. So in fact, the low-cost situation, consumers were not generally out of pocket. Now, with Monarch, an even stranger thing happened, or is happening right now, because the packages sold are protected under our UK protection scheme. Great, but lots of people have bought seat only, on a flight seat only on Monarch Airline, and the government has been repatriating them all. Why? Under what regulation? I don't know. I suspect this was more to do with public relations than anything. But it makes it very difficult, you know, and then companies are saying, well, why are we paying money for protection, for consumer protection, if the government is going to step in and do all this work anyway? So a very puzzling thing is happening there, which nobody quite understands. Anyway, I'm done now, so I think it's question time, Peter, is it?
What?